Welcome to another 5-minute mortgage update from your real estate financing experts at Landonia. Thank you for joining me. I hope you are having a great day. Our segment today was created with the help of Loza Law Firm, who helps us with legal research that is often necessary to make sure we only bring you the best and most accurate information. As always, I promise that in the next 5 minutes, you will learn something useful. You will learn something new about mortgages and real estate. Today's topic is mortgage forbearance for FHA or government loans. Forbearance is a program that allows you to postpone your mortgage payments for a specific period of time. Today, I'll be talking about how this program works for FHA loans. So let's first find out if, in fact, you do have an FHA loan. The best way for you is to simply look at your mortgage statement, and if it contains a case number, that means you do have an FHA loan. If it does not, you can go to the webpage addresses on the screen and check if your loan may belong to Fannie Mae or Freddie Mac, which would make it a conventional loan. If that's the case, please exit this video and watch another recording that is posted on this channel that specifically covers conventional loans. But if your mortgage statement does show a case number, meaning it's an FHA loan, then let's proceed and briefly discuss how that loan functions within the mortgage system. When you make your mortgage payment, you normally send it to a mortgage servicer who then services your account according to instructions it receives from HUD, Department of Housing and Urban Development, that oversees all servicing aspects of FHA loans. When instead of making a payment, you reach out requesting payment assistance, your servicer cannot really do much outside the instructions it receives from HUD. So let's now examine these instructions in closer detail. The specific instructions are contained within a Mortgagee Letter 2020-06 that not only establishes the concept or the program of forbearance, but it further states that the lenders cannot deny a request for forbearance. So that means that each client that calls a lender must be given the forbearance plan. It also states that the initial forbearance period must be for 6 months, and the duration of the forbearance may be shortened or extended at the borrower's request. It also states that each borrower must be evaluated for a standalone partial claim. Now, that is simply a no-interest junior lien on your property that becomes payable upon sale or refinancing of the house. Now, this is critical since it implies that after the forbearance period is over, a client does not have to repay the amounts that have accumulated in forbearance in either lump sum or through a repayment plan. Those amounts will simply be wrapped up in a second mortgage that will not have to be repaid until the house is sold or if you're trying to refinance. It goes on to highlight some requirements that a client needs to fulfill in order to qualify for that standalone partial claim. The mortgage could not have been more than 30 days past due as of March 1st. You must be able to resume payments and the property must be owner occupied. Now, this sounds really, really good, but then we move on a little farther in the document and get to a point where it states that there are no guarantees that this partial claim will be approved. It goes on to say that lenders may elect to use other loss mitigation options. It implies repayment plans or loan modifications, or they may proceed and exercise all rights under original mortgage terms. That would mean collection, that may mean foreclosure. And with that, the document ends. So let's look at the time after the forbearance ends. I am not trying to discourage you from obtaining forbearance, but I'm simply stating that there are no guarantees. The partial claim option is not guaranteed. So if you are not offered one and you're using forbearance, you must be prepared to repay the amount at the end of the forbearance using a repayment plan or you can hope for a loan modification. However, as of the date of this recording, May 13th, 2020, HUD has not issued any specific guidelines about the application process or qualification requirements for any of these options. Now, when and if they do, I will, of course, bring them to you, so please stay tuned for updates. Please send me an email with any questions you may have. Follow me on Facebook, and of course, subscribe to our YouTube channel. If you have questions regarding any real estate related legal matters, feel free to contact attorney Mark Loza. As always, if you like the material, give us a thumbs up and share with your friends. Thank you for your time. From all of us, mortgage experts at Landonia, stay healthy, stay safe.